Hello and welcome to this video on intellectual property protection in the wider context of international law. My name is Henning Gross-Roos-Kahn. Moving on then to the purposes of international intellectual property agreements. So we've said that we have so far still effectively in most countries around the world protection being governed by local laws. And these local laws historically often have favored the national interest or the protection for national right holders rather than foreign right holders. At the same time, still, we have international treaties on the protection of intellectual property which have been around for a long time, more than 100 years. So we have to probably ask if the protection essentially still is based on local national laws. What is the purpose of these treaties? The purpose of these treaties is threefold, so to say. In one way, these treaties try to address some of the difficulties which arise out of the system of very territorial local protection of intellectual property. So these treaties for a very long time have granted so-called priority rights, in particular for trademarks and patents and other rights which need to be registered. Because once you register a right in one country, say, think about a patent, you apply for a patent in one country, and then technically someone else might try to apply for a patent for more or less the same invention in another country, and you wouldn't necessarily have a security of being able to have a right to register the same invention in other countries. Hence, a system has been created which gives you, as someone applying for a patent in one country, a priority period of 12 months within which you can also apply for the same invention abroad. This has been expanded in various other treaties, in particular the so-called Patent Cooperation Treaty, the PCT, which allows companies to apply for a patent and designate this sort of patent application as an international application, which they want to effectively obtain protection for this technology in various countries. If these countries participate in the PCT system, then that leads to an opportunity to effectively obtain patent protection, again based on the local laws, but under sort of a harmonized granting procedure in some extent under this PCT system. So this local and territorial aspect of the application process to some extent is covered by these international treaties. Similar mechanisms are available for registering trademarks that one can use a system, the Madrid system in particular as it is called, to obtain trademark protection not only in the country of origin or not only in one country but in various countries abroad, with a so-called one-stop shop system of applying for a trademark. Now, in addition to that, the international IP system has two other purposes, and these are also important for businesses to be aware of, because they will allow you to make some or have some expectations about how protection abroad of your intellectual property would be like. So first of all, a basic principle is that as a foreign right holder, you're not supposed to be treated any less favorable than right holders who are nationals of the country where you operate or are having their main residence there, and so on and so forth. So foreign right holders must in principle be treated in the same way, with no less favorable protection available to them, the so-called national treatment principle. They must be treated as good as the nationals of a particular country. And this is something which in some countries' laws at least is even a principle which can be applied directly and which foreign companies can rely upon directly in front of national courts. It depends on how that respective country allows and whether it allows the application of an international treaty, but in some countries this is allowed and right holders can claim directly not to be treated any less favorable. Another last element about these international treaties, which I will discuss a little bit more, is that these treaties oblige countries to provide certain minimum standards of protection for foreign right holders. And these minimum standards of protection concern essentially all intellectual property rights nowadays. And I will use, as you will see in the following slides, in particular examples from the WTO, the World Trade Organization's agreement on trade-related aspects of intellectual property rights, the so-called TRIPS agreement, and I will provide an overview of this agreement in a few minutes. So the TRIPS agreement is in that sense the most important global agreement on the protection of intellectual property. The TRIPS agreement incorporates the existing previous agreements, especially the Berne Convention and the Paris Convention, by making compliance with these treaties part and parcel of the TRIPS obligations itself. So all WTO member states essentially have signed up to this basic set of standards which originates from these different international intellectual property treaties. And TRIPS, like I mentioned in the general example before, also uses these principles of non-discrimination, which allows right holders from abroad to expect the same standards of treatment as local right holders and nationals of a particular country would have and enjoy under intellectual property rights. And lastly, also TRIPS in particular contains all these minimum standards of protection in essentially all areas of intellectual property rights, in copyright, trademarks, industrial designs, geographical indications, patents, and so on and so forth. So just a few words on the standards in the three main areas, copyright, trademark, and patent in particular. So copyright protection under TRIPS, in particular combined with the standards under the Berne Convention, which is, as I said, essentially part of the WTO law as well, in the broadest sense covers any sort of literary and artistic works. They do include explicitly software, computer programs, and databases which must be protected under copyright. They do provide for essentially all the basic exclusive rights that the right holder is the only one who is essentially allowed to make reproductions of a work, to communicate that work to the public, including in today's environment primarily by means of broadcasting and so on and so forth. There are further treaties which would deal with communication online and so on and so forth. And these treaties, especially again the TRIPS agreement, also contains basic rules what countries can introduce as exceptions from copyright protection, so that they, for example, would allow making copies for private or personal users, or making copies done by libraries and so on and so forth. For these exceptions, for example, it is not something where the TRIPS agreement provides any detailed guidance. TRIPS only sets out basic standards that when countries introduce exceptions, the core economic interests of the right holders must nevertheless be taken into account. But here, for example, details would very much depend on the local context and on the local laws. So especially when we talk about exceptions, and that's something which applies both to copyright and to patents and also to trademarks in a way, in all these areas, what kind of exceptions from the exclusive rights the right holder enjoys are available, that would essentially depend on the local laws of the country where the relevant copyright protected material or patented invention or trademark protected sign is being used. Well, moving then on to trademarks, the basic principles of trademark protection have equally been harmonized under the TRIPS agreement. So TRIPS essentially says that any kind of sign which can be perceived visually, which can be perceived by the human eyes, must be protected under trademark law if it is capable of distinguishing the goods and services of one entity from those of another entity. This is the core idea of distinctiveness of signs. Only those kind of signs which are distinctive, either because they're inherently distinctive, because they're fancy names like Google. Google is a term which is inherently distinctive because it doesn't really have a meaning, for example, in English. It doesn't have a meaning in any other language I would be aware of, whereas other terms might not be inherently distinctive but might have acquired distinctiveness over a long period of time. And consumers have become to know a particular term. So these things in principle must be protected. But again, the question of what exactly distinctiveness means and how courts assess it, what degree of acquired distinctiveness, for example, courts would demand, that all depends on local laws. TRIPS provides the basic framework, then this is implemented in the local laws. And the same comes with regard to the exclusive rights which a trademark holder enjoys, basically protection against someone else using an identical or similar sign in relation to identical or similar goods and services, if that is likely to confuse consumers. This idea of consumers being confused is the core of trademark protection. That is also embedded in the TRIPS agreement, and that is some kind of protection one can expect in most countries around the world. But again, the question of how consumer confusion would be assessed is something which courts and national laws might take different approaches to. Lastly, a similar picture in patent protection. Patent protection under the TRIPS agreement must be available for all fields of technology. That is actually quite an important aspect of the TRIPS agreement, because before the WTO and before TRIPS, quite a lot of countries excluded various fields of technology from patent protection, in particular pharmaceutical products or agricultural products or other aspects, chemical products to some extent. Now with TRIPS, and especially with the transition periods for most countries except least developed countries having lapsed, essentially all countries in the world which are not least developed countries must include in their laws also protection for example, pharmaceutical drugs under patent law. TRIPS again provides some opportunity to exclude certain issues from patent protection. I mentioned at the beginning already that living material, plants and animals can be excluded. Also the degree and the amount of protection available for specific aspects of pharmaceutical drugs can vary quite a lot. Just as an example, in India, for example, you can of course obtain patents for pharmaceutical products, but if your invention relates to a new form of a known substance, so you have found out a slightly improved version of an existing molecule or compound, that improved version can only be protected under Indian patent law if it shows what the Indian Supreme Court calls enhanced efficacy, and that primarily is understood as therapeutic efficacy, as the ability to heal. Other countries take a more relaxed approach on protecting these kinds of incremental pharmaceutical innovations, and for example also easily grant protection for new uses of an existing known compound, whereas again this might differ in a lot of countries' laws. So again, the local context is very important. Now this basically more or less concludes my first part of the talk. Just to say, as a last element of the WTO TRIPS agreement, that this agreement contains also provisions which require countries to provide remedies for right holders, for those who have intellectual property rights in the local laws. So these kind of remedies cover the basic kind of remedies one as a private party would expect in national systems of procedural law and litigation. So you have a remedy, a right to request damages once there is an infringement of intellectual property rights. You have a right to ask for injunctive relief, so an ability to stop another party using that patented product or that copyright protected work or the trademark protected sign. So these basics are again set out in the TRIPS agreement, but again the details may vary in national laws. Just to mention one case which might sometimes surprise a lot of people, China was sued by the United States in 2007 because China had at that point a system which made criminal sanctions against particular grave violations of intellectual property rights subject to those who faced these criminal sanctions who were charged of having more than 500 illicit, illegal copies of, say, copyright protected work on their premises. Now, if someone had less than 500 copies, that person would not be subject to criminal law sanctions. It could still be subject to private civil lawsuits for damages, but often the criminal sanctions are the ones which prevent someone from actually infringing, because no one really wants to face criminal sanctions in this regard. So the Americans argued that this level of 500 copies as a threshold for criminal liability under Chinese intellectual property remedies would be arbitrary and in breach of the TRIPS agreement. The TRIPS agreement in the relevant article 61 talks about that every country must provide for criminal sanctions against willful copyright, piracy and trademark counterfeiting on a commercial scale. And the core question was, what does it mean to have something on a commercial scale? The panel in the end decided this depends on local situations, it depends on what kind of a product you're talking about, what the market is. And because the Americans didn't provide evidence that for a particular product on the Chinese market, the 500 copies threshold was, in that sense, a wrong threshold, they didn't win this particular case. It's an example on how the TRIPS agreement, with the use of often general terms like commercial scale, which can be understood in various ways in different national laws, sets only a basic framework, a basic standard, what one might expect in terms of protection, and that again, as I mentioned several times, the details depend on the national law. This so much would conclude my first part of the lecture, and I will now move on to the second part, which discusses the protection of intellectual property when we see it in the wider context of international law, and when we look at areas of international law outside intellectual property protection and how they might play a role for how protection is afforded in different national laws. From a business perspective, here again the strategic consideration is that one should be aware of these different areas and the politics and the types of movements and considerations which are quite dynamic often, and how these change, because this might well affect how intellectual property is protected in different countries. So in this second part I will use various examples. The first example I want to mention is the protection of investment under international investment law and how that may serve as an alternative mechanism for protecting intellectual property rights. It is something which in that sense can provide an alternative route for right holders to protect intellectual property in other countries, but as we will see, it is a mechanism which is in a way dependent on various considerations, and I will give examples to this effect. The second part of this section will discuss how considerations of protection of public health, of the environment and of biological diversity under international treaties might affect the protection of intellectual property and how it is available in local laws. So if we start with this concept of protecting investments under international investment law, the slide you see here, the first one discussing or showing the world with the title of a 2013 political risk map essentially is there as an example to show the wider context of this system of investment protection. It's essentially a system which has been designed post-Second World War by primarily now OECD countries, which wanted to ensure that their own investors receive some degree of legal certainty and legal protection for their investment they make in less secure countries abroad. So these would primarily be investments made in countries, for example, in Africa, in Asia or in Latin America. But nowadays investment treaties also are made between countries which are members to the OECD or between countries anywhere in the world effectively. These treaties often are based on bilateral relations in the sense that two states alone rather than a larger group of states would conclude these treaties, and they are quite numerous. We have a total of more than, I think, 3,000 of these treaties in force at the moment. And the important features of these international investment law treaties is that they effectively provide an international law mechanism to protect the assets of the foreign investor which that investor has brought into the host state. So the kind of assets we're talking about might be real property, of course, might be contracts, might even be shares and so on and so forth. And as we will see in most of these treaties, these kinds of assets would also include intellectual property rights. That's how the connection between intellectual property and the system of investment protection comes into being. As I've mentioned, the international tools for protecting these investments is primarily in form of bilateral treaties called bilateral investment treaties or BITs, and you also see these investment protections being included in wider free trade agreements. The NAFTA, the North American Free Trade Agreement, signed alongside the WTO TRIPS agreement in the 90s, is a very prominent example for an agreement including an investment chapter. The WTO so far, just as a side note, has not been able to agree on standards for the protection of investment, and there has been several attempts to negotiate a multilateral treaty on the protection of investment, but that always so far has failed. Now, that's why we have these bilateral or regional treaties which cover these kinds of protections. The kinds of protections available under these treaties tend to be protections against discrimination. They tend to protect the investor against expropriation and for something what is called fair and equitable treatment, a very broad and ambiguous term which has been given different interpretations by different international tribunals which have decided on this. That brings me to my last and probably most important feature of this system of investment protection, and that is that this is probably the only, or if not one of the only areas of international law where a private party, a company for example, or an individual can directly bring a legal action against a state. So under the WTO or under most other areas of international law, this is only binding upon states and will also, if at all, involve a system of settling disputes between states. Here, however, we do have opportunities for private right holders, for investors, to bring actions against the state. And that, of course, can be an important element in intellectual property issues as well, in particular to the extent that these investment treaties protect intellectual property as a form of investment. Now on the next slide you see the number of cases called ISDS cases, Investor-State Dispute Settlement cases, and you see that basically with a very, very sort of few cases until the mid-90s, end of the 90s, From 2000 onwards, the amount of cases has gone up. Still, we're only talking about numbers of around 50 onwards or so cases per year. But these cases often are quite high profile and can amount to almost, well, in some instances, a change in the behavior of a state onto how it regulates a particular aspect. And states have, in response to these increase of these cases in more recent years, probably since about 2005 onwards, try to also make sure that this system cannot be abused by investors. So there's, as some academics have called it, a return of the state in trying to sort of prevent this system to be used only in favor of investors, and they include certain safeguards for the state's right to regulate. Now, I want to use one example of a dispute where intellectual property has played a major role. This is a dispute which the American pharmaceutical company Eli Lilly has brought against Canada. And the background to this dispute is that Eli Lilly has obtained patent protection for its drugs Strategia and Suprexa in various countries of the world. So these drugs have received patent protection in, for example, the US and various European countries, and also in Canada. Initially, Eli Lilly had been able to obtain patents for these drugs. Now, however, under a specific doctrine in Canadian patent law, these two patents were revoked by Canadian courts. So the Canadian courts essentially decided that the patents shouldn't have been granted in the first place because the patent lacked what under Canadian law is considered a specific version of the standard of usefulness or industrial application which each patented invention needs to show. I will not go into the very details of what exactly the Canadian law says on this, but to say in a nutshell that the Canadian law requires the patent applicant to disclose in the patented invention the specific utility which follows from the promise, so to say, which the patent applicant makes in his patent claims, in the patent application, the way he describes his invention to work, and then he has to effectively show that this actually is true and can be shown by research data and can be proven or at least soundly predicted to have a specific utility. Now, this was detrimental to these two particular patents by Eli Lilly. Eli Lilly appealed the decisions of Canadian courts to revoke these patents. However, also in the appeal instances, the revocation was upheld and Eli Lilly effectively had lost its patents for these drugs in Canada. While, as I mentioned before, other countries, such as the US, had found these patents to be valid, and Eli Lilly was able to enjoy patent protection in these other countries. Now, Eli Lilly was then able to rely on the special system of investment protection under the NAFTA, the North American Free Trade Agreement, which allows an investor of one of the NAFTA states, here Eli Lilly was an investor which had sort of its main residence or establishment in the United States, to bring an action against any other NAFTA state, including Canada, for activities which essentially affect this investment. And the standards which Eli Lilly has been essentially invoking here are standards of protection against expropriation and standards which required Canada to protect the investments of Eli Lilly, here the patents, in a fair and equitable way. The dispute is still ongoing. We don't yet have a decision. We don't know exactly what the tribunal, which is charged to decide on this case, will decide. It is, however, an interesting example on how investors have been using the system of investment protection to obtain protection for their intellectual property rights. Quite a lot of people have been arguing that this system of investment protection potentially interferes with existing national systems of intellectual property rights, and it may well be that states in the future will try to push back and try to limit the ability of investors to use these kinds of mechanisms to protect intellectual property rights. At the moment, however, it's one consideration which companies can take into account. One would, of course, carefully have to look at whether a particular country where one wants to do business in has an investment treaty with the country from which one's own company originates, where one's own company is established, and then one would have to look at the details of that treaty, how that treaty protects investments, does it include intellectual property rights, what kind of standards are provided, and so on and so forth. In any case, that's one area of international law which does affect, outside the core of intellectual property treaties, the protection of intellectual property rights. Then, moving on, I will discuss three areas which may often rather function in a way that they will limit the basic concepts of intellectual property protection in foreign countries in certain aspects. Now, the first of these areas is the area of the protection of biological diversity under international law. We have a set of international treaties which deal with this kind of protection. However, as a starting point, one has to look at it from the perspective that the overlap between biodiversity and, in that sense, genetic resources and intellectual property rights originates from the situation that from the 1980s onwards, basically with the lead of the United States, more and more countries accepted some degree of patent protection for living organisms, for plants and animals in particular. And the sort of leading case, or one of the leading cases, was a decision in the United States where the United States Supreme Court in 1980 decided that a bacterium which can be used in order to break down crude oil, and that in turn can be used effectively to deal with oil spills on the high seas, that such a bacterium can be a patented invention, and that therefore this kind of a living organism can be subject to patent law. Essentially, patent law has since then taken on board the needs of the biotechnological industry and has enlarged its scope of protection to cover biotechnological inventions which involve living organisms. As I mentioned before, TRIPS takes this into account by requiring all countries to protect at least microorganisms under its patent laws. But, for example, doesn't define the term microorganisms, so there is again some flexibility here. Now, with that in mind, we can then look into situations where the patents have been obtained in relation to what in some countries is considered to be traditional knowledge, something which knowledge relating to the use of, for example, plants for medical and therapeutic purposes. An example here again would be that there were attempts to patent in the United States the use of turmeric, which is a particular ingredient which has been very long used in India by indigenous communities for wound healing purposes. Now, that knowledge was not properly recorded, at least was not available to the US Patent Office when they initially assessed the patent application. There was a grant for a patent in relation to turmeric for wound healing purposes. Now, that later had been revoked, but all of this essentially triggered a debate, and similar cases triggered a debate from countries which were rich in biological resources and which were having various communities, domestic indigenous communities, which have had a long history of using plants for various purposes, that these kind of genetic resources and the traditional knowledge associated with them should be particularly protected, and that one should take care that patent rights do not effectively appropriate these kind of knowledge or these kind of genetic resources without there being some sort of an agreement and arrangement with the countries from which these genetic resources originate, or with the communities who have been holding this kind of knowledge in the past. Now, these kind of principles for the protection of genetic resources and traditional knowledge are primarily embodied in a treaty which is called the Convention on Biological Diversity, which has been signed in the early 90s. It has a very large membership. An important exception to the membership to the CBD is the United States, who has signed but not ratified this agreement. This agreement essentially is based on the idea that states have sovereign rights over their genetic resources. This is in particular important area to consider for any company who works on living organisms or is using in its own sort of inventions genetic resources which may have originated from a country which is member to the CBD. This is because that the CBD effectively establishes a basic framework whereby the use of genetic resources has to be based on the permission, and access has to be granted with prior informed consent of the country from where the resources are originating. One has to essentially agree on the terms under which these resources can be used. And this now, in a more recent treaty, in the so-called Nagoya Protocol on Access and Benefit Sharing, which has been signed in 2008 and which has come into force recently, where now, for example, the European Union also has begun to implement this agreement. This later treaty, the Nagoya Protocol, has provided some more details on the framework on how this benefit sharing is supposed to happen. In the IP context, the Nagoya Protocol doesn't give a detailed perspective on how exactly one has to deal with genetic resources and traditional knowledge in the context of patent applications, but quite a few countries, especially biodiverse countries such as India or Brazil and others, have been considering to introduce in their patent application processes a requirement where anyone who wants to apply for a patent in these countries has to show whether or not it is using genetic resources, whether the invention is in any way related to or based on genetic resources. And if so, that company or applicant has to show that the genetic resources have been obtained with the prior informed consent of the country from where the resources originate, and that also these resources are being used in accordance with an agreement signed with the relevant institution or indigenous community when it relates to traditional knowledge, that the company using these resources or knowledge is allowed to do so. So in the future, one might expect more and more countries probably considering the question of genetic resources and traditional knowledge within the context of patent applications. So businesses who are in, for example, cosmetics, in pharmaceutical, or in other areas where traditional ways of using substances from nature plays a role, might want to take into account whether and in which countries such kind of considerations of protection of biological diversity play a role. And this may be one further element which might affect strategies and might be an important consideration in making business decisions on what kind of products to market in what kind of countries and what kind of considerations to take into account. From then I will now move to another area, the protection of public health under international treaties. Here there is several examples one could give, one could look into. However, I want to focus on one example which has been becoming quite prominent in the recent years, and that refers to the regulation of tobacco products and how tobacco products can be sold in various countries. There's an international treaty from the World Health Organization, which has again a very large membership, the so-called Framework Convention on Tobacco Control. And this international treaty, amongst other things, establishes rules on how tobacco products can be advertised, and importantly, in its guidelines encourages countries to introduce something what is called plain packaging. Now, plain packaging is the idea that, as you will see on the slides as an example, there will be hardly any place for brands or logos on the packaging of tobacco products. So cigarettes can effectively only be sold in packages which contain warning images in a prominent part on the packaging of the product, and warning messages as well, whereas there's only a very limited amount of place on the packaging left for the display of the brand as such. And often one can only use the name of the product, one cannot use a combination of colors, one cannot use a logo, and so on and so forth. This is not only important for the tobacco industry, although at the moment it is essentially focusing on tobacco. It may be something which companies working in other sort of areas such as sweets, such as alcoholic beverages, and so on and so forth, also have to take into account that the marketing and labeling of their products will be subject not necessarily to plain packaging, but to similar kind of restrictions on the use of trademarks, and that therefore this is another sort of area where they have to take into account public health considerations. There is a particular dispute which is ongoing where an American tobacco company, Philip Morris, is under investment treaties, again suing Australia and Uruguay. One of these two disputes has recently been, at least on a first stage, been decided against Philip Morris. There's a further dispute on this going on in the World Trade Organizations, where various countries are suing Australia. It is a good example on how different areas of international law all come to play in one area, in one sort of instance, in a way: health, intellectual property, investment, and trade law. And a core question in this way would be how, for example, these health considerations are balanced against the consideration of protection of intellectual property. And often this will be, again, primarily something which an individual country will decide and choose to do as it desires. Now, the last area I want to briefly mention, again an area where potentially considerations which are outside the core idea of protecting intellectual property might have an important bearing on how intellectual property is protected, concerns climate change. Now, climate change has a link to intellectual property primarily because within climate change negotiations, a discussion for quite a while has been about the treatment of so-called green technology or environmentally sound technologies, or whatever other terms may be used. The idea is that one, in order to deal with climate change, needs to facilitate the widespread use of these green technologies. So this, on the one hand, can be so-called mitigation technologies, technologies which help to slow climate change by reducing greenhouse gas emissions. So this would be particularly clean energy technologies, right? Solar and wind power and other things, but also the concept of so-called adaptation technology. So these adaptation technologies are much broader because they cover essentially any sort of technology which helps a country to adjust and cope with climate change. So any technology which, for example, in a way addresses rising sea levels, which, for example, addresses weather changes, increased droughts, and so on and so forth. So the concept of environmentally sound or clean or green technologies can be very, very broad. And often, especially developing countries, have taken a position that they want to be able to limit intellectual property protection in order to facilitate the transfer of these technologies. There is, under the UN Convention, under the UN Framework Convention on Climate Change, a particular general provision in Article 4, which includes a basic obligation for developed countries to effectively take measures to transfer and encourage the transfer of these environmentally sound technologies. However, there is no indication how that is supposed to relate to intellectual property rights. This has ever since been a contested issue in the international negotiations. You see on the next slide various examples which had been proposed in 2010 in Copenhagen. Similar examples were initially part of the Paris negotiations in the end of 2015. In the end, none of these examples so far have made it into an existing treaty. The important aspect in general is to consider that in the context of climate change negotiations and in the context of dealing with climate change, it is not unlikely that environmentally sound technologies and the protection they are able to obtain under intellectual property rights may at some point be subject to specific approaches in the national law or even under international regimes. That may be approaches which particularly facilitate these technologies to be protected, or maybe approaches which particularly aim to limit intellectual property protection for these kinds of technologies in order to make them more widely available. This is another area which should be within the broader sort of perspective of those considering to do business abroad in relation to intellectual property. So with that, I would conclude my second part, just to maybe briefly summarize what I've tried to get across here. So from a business strategy perspective, the main take-home lessons from this is that intellectual property is primarily something which is vested in the national laws of each and every country. We have common standards which sometimes are more specific, sometimes are more general. These common standards provide some degree of reasonable expectation for what things would be protected in most countries' laws, but the details on how this protection effectively looks like will essentially be based on that country's national law, and it is therefore imperative to look into the degree and extent of protection in that national law before one makes a particular business decision on how to sell goods or offer services or otherwise operate in relation to intellectual property rights in a particular country. That's sort of the first part in a very, very brief summary. The second part is just to emphasize that outside intellectual property law proper, outside the core area of intellectual property law, there will be various other legal regimes which affect the protection of intellectual property, where countries might, for considerations which have nothing primarily to do with incentivizing innovations or creativity, either provide additional or less protection for intellectual property, and that in an interconnected global world, these other considerations in the future are more likely to become ever more important because when we face global problems such as climate change, global solutions or effective solutions to these problems might be ones which leave systems like the intellectual property system not unaffected, and it therefore is an important consideration to look beyond the specific area of intellectual property to be aware of wider developments and how they might affect intellectual property. Thank you very much.